Now, the third point which I am making, that, my lord, who we are, I have not stated, I am very sorry. Out of 39 castes, we are also scheduled caste. We are not backward class or educationally or socially backward. No, that is backward class we are. But actually we are scheduled caste. Out of 39 castes, 37 are our caste. And the reservation has been given to 2 castes. The difference between these, ours and theirs, is almost negligible, except this, that these Valmikis are, as said to be, manually scavenging the dirt also, everything. But at the same time, who we are, I'm just going to, as Mr. Sibal has also shown the list, that kindly see the list who we are. Who are, I already showed, snake charmer, a person who is cutting the crops, harvesting the crops, labor, cobblers, barbers. These are the persons which has been, your lordship may kindly refer to, very interesting to see that we are like them. We are not different. We have not risen much in the, out of us.
Sagar, you may have a valid point, but again there, we will have to leave it open to you to set this up as a ground before the High Court. I'll tell you why.
If
Maybe
your lordship is...
I'll tell you, there may be some point to be deliberated on this on a more factual basis before the High Court, because they have picked up 2 castes, right? Now, suppose those who are excluded are in a position to show prima facie that, look, though we have been excluded, we rank on the same footing as the others who have been included and who have been given this preferential treatment within the SCs. Then the burden will shift on them,
of course,
to demonstrate what was it in regard to these 2 castes which the others do not possess. That is, you have excluded others
that
who are, according to them, similarly circumstanced. So they must then discharge the burden of showing that those who have been picked up are not similarly circumstanced.
It is just being submitted only for the reason that...
That is the factual justification.
Yes, that's what I was submitting, but I have only submitted that petition, the appellant side referred to this very list. In this was not mentioned at all. Rather, it was said that Mochi and other, etc., they are suffering for ages. I asked myself, Mochis are we, laborers are we. Your lordship, very interesting example, the example I give, my lord, which is, if I don't have the evidence, but it is correct, that scavenger, your lordship, is collecting the dirt. It is being loaded to a truck. Truck driver is a backward class. Truck driver is a scheduled, another scheduled class, who is not Valmiki. Invariably, this is happening. Very interesting instances. A person who are in this class...
advanced class also...
my lord, your lordship may see, they may have the reason to say that they are weakest. Very well, they are weakest.
See, but therefore, what the point I'm trying to tell you is that I'm not saying that you don't have a point on this, but this is a point which has to be argued when the constitutional validity of the act.
I'm just saying, for giving a preface.
Your wider point is that bifurcation is per se impermissible.
Yes.
Now what you are saying is that, look, in the alternative, I'm putting it in the alternative, even if it is permissible, it can't be justified because those who have been excluded by this act from the preferential allotment are in all other respects similarly circumstanced, or at least some of them. May not be all the 37 are similarly circumstanced, but out of the 37, you can certainly establish before the High Court that we fulfill the same parameters of backwardness in relation to those 2 who have been included.
That's right, my lord. But I'm
saying something in your favor.
Yes, it seems, in first perception, it seems. I'm very grateful. But as a matter of fact, your lordship may see, let me also submit, there are other points also, that we have not excluded or included in that. We have given a preference. There is a marked difference between preference and reservation on one side, and preference and certainly an exclusion are also not very, your lordship may having a much difference.
So what is the submission?
One way of saying.
What is the submission?
Submission is this, that they do not have power, and it relates to exclusion. It literally relates.
It's already argued by Mr. Swaroop. The
Yes.
power for exclusion and inclusion solely rests with the parliament, and the state does not have that power.
That is in my favor. If state doesn't have that
That
power,
is already argued.
that is argued. I'm just supplementing. I will not give any details to that. No, I'm supposed to give because
is-
he has very elaborately dealt it. That's I'm grateful to him.
That is the best
But
point. That is the
it's-
best point that you have.
Yes, that was
So
supplement.
we'll say that the power for exclusion is not with the states. That is a formulation which
Yes,
Mr. Swarup has substantially argued that point.
Please, my lord.
What is the next point now?
Yes, next point, my lord, I'll come. Please refer to the written written submissions.
Just formulate.
Yes, it is. Whether the state has legislative competence to enact the provisions contained in section 4, subclass 5 of the Act.
Legislative competence.
Legislative competence, because we are supported by E.V. Chinnaya's case that no, as a matter of fact,
Legislative, actually, Chinnaya has talked of legislative competence, but I think it jumbled up the issues. Legislative competence is a term which is applied to the division of powers not division of entries in list 1, list 2 and list
yes,
3.
then Chinnaya has,
Really speaking, the power either exists or it does not exist under Article 16(4).
yes,
So Article 16(4) is not a matter of competence, it's a matter of constitutional authorization.
yes, Chinnaya has, if
So,
your lordships may
I know that
recollect,
one para, they say that
Yes.
therefore it is not referable to entry 41 of list 2 or entry
exactly
25 of list.
the doctrine of pith and substance was applied there in that case also, and inter alia stated that actually that this very act is
Competence they have. It will be very far-fetched to say that legislative competence is not there.
My lord,
Because entry 42 of list 2 says state public services.
Yes.
So they can enact any
41, my lord.
entire 41. The entirety of the gamut of state public services falls within the state legislative domain. Your point, however, is that while enacting a law under entry 41 of list 2, you cannot breach a substantive constitutional restriction
yes,
because
I was coming to that, my lord. I was
all legislation,
it is my, if you'll,
all legislation is subject to part 3 of the constitution.
then my lord.
But a part 3 argument does not go to competence, but to
Then
constitution.
my lords may kindly refer to Chennai. There are certain, my lord, let me refer it. It was Chennai.
Questions were formulated. Use that phrase, that's
That it was used
Leave
by.
it at that. I mean, that's okay. There's a passing remark over there in that paragraph.
Let's, my lord, may examine Chennai. Chennai is,
All right. Why don't you do this? You formulate the point. Let's have your formulation first.
yes, whether,
Not whether. Whether would be an issue. You are now submitting.
it's all right then, because in the written submission, it is written, I have just copied.
That's the problem. You are borrowed Mr. Hegde's arguments and therefore he has not properly framed it and you have to read it. It's better, he should be arguing from your
Why don't you
rather than.
formulate your submission?
Yes, my lords may see. My now submission is the state lacks, my lords, that legislative competence to enact the provision contained in section 4, subclass 5 of the Act.
1 second.
That is my submission is at page 33.
Your submission or Mr. Hegde's submission?
My lord may take me as a Hegde.
Personation.
Yes, if Indira Sani can become Indira Gandhi.
Why not Mr. Why not
As
Mr.
it
Sagar
is.
come, Sagar become Mr. Hegde?
Then take it as.
But then after Mr. Swarup's argument, the matter should have been over.
It should have
They are
been.
so homogeneous.
It should have been.
All right.
Sagar is relying on a deeming provision.
Obviously,
You
thank
are saying that the state lacks legislative competence to enact section 4, bracket 5 of the Act.
Please kindly refer
Now,
to it.
tell us which is the entry under which it will fall.
It will fall under, my submission would be, it neither falls under 41, nor falls under nor falls under 25 of the, this schedule 2, second. Concurrent list. If your lordships may kindly refer to page 33.
Why?
Because as per Chennai,
No, don't forget Chinnaya, because Chinnaya is what we are reconsidering now.
yes.
Right? For us, Chinnaya is not of a higher court, in which case we are bound.
No,
We are now
that is, I'm,
you have to argue it dehors Chinnaya.
no, my lord, with respect, if I am saying Chennai is correct, then I have to justify his.
Right, but that
that
we
Chennai
can't
is-
shut our minds, right? We are a bench of 7. We have to
Of
now
course,
deal with it.
Of course, my lord.
It's like arguing a first appeal. In a first appeal, before a high court, You never show that this is the judgment, my lords. You start with the plaint, you start with the issues, you start with the written statement, you look at the evidence. First appeal is judgment, the trial court judgment is shown at the end.
Yes,
So it's the
Your
same thing in constitutional matters. You have to argue it on first principle before us. Otherwise you get
Your
impatient.
Lordship may.
As we are tending to.
My Lords may refer it. My Lord, my respectful submission, if your Lordship may kindly refer to page 33. Section 5 of the Act very clearly says that 50% of the vacancies of the quota reserved for scheduled caste in direct recruitment shall be offered to the Balmikis and must be Sikhs, if available, at first preference among the scheduled caste. The respondent submits that this amount to an
So rather than reading the submissions, why don't you form your,
Just explain it to us, because why do you say it doesn't fall under entry 41? We got the point that this is unconstitutional because it breaches Article 16(4). That's a valid point.
I am very grateful, my
Valid
Lord.
in the sense
Now I
not-
will explain.
Not
Now I
valid
will
in approach, not valid in necessary.
That's why
conclusion.
if we kindly refer to the Act, the Act says, Act has made a subdivision on the basis of the caste. On the basis of the caste, it has been done, not in order to achieve any other objective like, for example, for appointment, furtherance of your Lordship may see appointments or a reservation, giving a
Can we
reservation.
suggest one thing? Can we suggest one thing? We've got your point. But it brings us back to your central point that this is a reservation on the basis of caste.
Yes.
Now, assuming you're right, we proceed for a moment to test your argument on that you are entirely right. So then, which is the constitutional violation? The violation is of 16(4), not of legislative competence.
Your Lordship.
Unless you say that the field is exclusively reserved for Parliament under entry 97. That will not say.
That would really, because here your Lordship is reconsidering Chennaiya. I am repeatedly, my Lords, saying one thing only, that the finding given in the Chennaiya in this regard is perfect. Your Lordship is going to consider whether it is wrong or right, or it is as per law.